Hi, my name is Darrell Harriman. I'm a California attorney. My primary focus is on probate and estate law, and I've been in practice since 1980. And for the last 15 years, the only thing that I've done in my practice has been probate and estate law.
Maybe we'll just start off with what is probate and why is it necessary?
Well, let's start with why it's necessary. When somebody passes away, they have assets that are in their name. There has to be some way of getting those assets from their name over to the proper individuals that they're supposed to go to. There are really two terms that we can identify. You've got the probate process just as a general process, getting the assets from the decedent over to the heirs. You also have, in some cases, the need for what I will call in our discussion a formal probate. And that involves a long court proceeding. They're not needed in every case. That's one of the reasons that people that have dealt with a death in the family should talk with an attorney. There are several alternatives, if the facts line up correctly, where you can avoid the need for a formal probate. But for our discussion, I'll just refer to the probate process and to formal probates.
Can you tell us the difference between testate and intestate probate?
Yes, really pretty simple. Think of a last will and testament. Testament, testate. A testate estate is one where there's a will. An intestate estate is when there is no will.
What are common misconceptions people have about the probate process?
Is that some people think the process will take care of itself. It won't. Assets do not get from the name of the decedent into the name of the heirs unless somebody intervenes and gets involved. I've had one estate literally where nothing was done for 50 years after the individual passed away, and going back after that length of time and getting the assets transferred was just monstrously difficult. New generations had come in. You need to do what needs to be done as soon as you can after the death.
What are the typical steps in a probate process?
Well, I would tell people the first thing to do is, as mentioned before, talk with an attorney to find out what process is going to be the best process for you. Can we avoid the need for a formal probate? That's step number one. If a formal probate cannot be avoided, it's going to be started with a petition for probate, which is going to request that somebody, in most cases it's the client that's walked into my office, will be appointed as the representative of the estate. And we'll talk a little more about those details later.
How long does the probate process usually take, and what factors can affect this timeline?
If a formal probate is not required, in most cases it's going to be a matter of 4 to 6 months that you can get things resolved. If a formal probate is required, the time involved can be anywhere from best case scenario about 10 months to several years. It really depends on the particular issues that come up in the probate process. I would say that the vast majority of probates that I've handled, we've been able to resolve within a year to a year and a half.
What documents are required to initiate the process?
Probate petition that's filed with the court. This is a 4-page document requesting that somebody be appointed as the representative of the estate. The hearing on that petition for probate is held usually 5 to 6 weeks after it's filed. There's notice that goes out in the meantime. There's a notice published in a newspaper in the meantime, so that people are aware that this is going to be taking place, and they have the opportunity to appear at that hearing if they feel the need and object to the appointment. Assuming there are no objections and everything else is done properly and in order, the court will approve the appointment of the personal representative of the estate at that hearing.
What are the typical costs associated with probate, and how are they calculated?
In a formal probate, you have both costs and fees. I'll talk first about the costs. You're going to have filing fees with the court, one at the beginning, one at the end. Those typically are going to be right around $500 each. You'll have the need for publication of a notice of death, and the cost on that varies hugely depending on the community you're in. If you're in Los Angeles proper, where there are many, many legal newspapers competing with one another, it's typically going to cost in the neighborhood of $250 to $300. But I've had outlying communities where there's maybe just one publication that is authorized under the law, and I've seen them charge as much as $1,200 to $1,500 for publication of the notice. You have certain other court costs for issuance of letters appointing the personal representative. Those are the costs involved. Usually I'll tell people you have to figure on costs of $1,500 to $2,000. The fees that are paid to the attorney in a formal probate are based on a formula that looks at the total value of the assets going through the probate process. And it's a sliding scale. I won't go through all the details of that, but you go anywhere from an estate that's worth maybe a couple $100,000 would cost in statutory attorney fees about $7,000. If you have an estate with assets of $1 million, it's going to be attorney fees around $23,000. And you also have fees for the person appointed as the personal representative of the estate. They use the same formula for calculation.
Are there ways to minimize probate costs for my estate?
Well, the costs you don't have much control over. As I mentioned, their court costs, their publication costs. In some cases, people can delay those if they have a financial hardship. They can get the court to waive the initial filing fee, but because there are going to be assets available from the estate at the end of the matter, that's going to have to be paid at some point in almost every case. The other thing I would say to actually, in most cases, keep the costs down, it's get a good attorney. Even though you're paying the attorney the fees that you'll have to pay, if they understand the process, they can usually save you far more than you're paying them by handling the estate properly and getting it done correctly the first time.
What are some common challenges or disputes that arise during probate?
Probably the most common, people think of the term a will contest. If there is a valid reason for claiming that the person at the time they signed the will either didn't understand what they were doing because they weren't sufficiently competent mentally or physically to understand it, that's a basis for challenging. If they were under duress, somebody holding a figurative gun to their head to get them to do it, if they were defrauded into doing it, there may be a basis for challenging the validity of the will. Sometimes, even when there is no will, you can have fights over who is going to be the personal representative of the estate. And that can delay the the processing of the state considerably, depending on how hard people want to fight over that issue.
How could families prevent conflicts during the probate process?
Well, just don't have sibling rivalry. Have relatives that aren't contentious. The reality is, if there are underlying resentments in families, probates draw those out. It's kind of their last shot at one another, and you learn that as an attorney, that even though you do your best to minimize friction, you can't always avoid it. There are certain people that just want to have a fight. Now, as the executor, the thing that I find can minimize that the best is to actually communicate. The biggest single sore spot, and the reason that I get calls from beneficiaries most frequently, is they say, nobody's communicating with me. I don't know what's going on. If there's no communication, it breeds distrust. And if you have an executor that is careful about keeping people informed, goes a long way to keeping down the friction during the probate process.
What are the responsibilities of an executor during probate?
Well, let's talk about the term executor. I've been using the term representative, which is kind of a generic term, because there are different titles. If there's a will involved, the person that's appointed is called an executor. If there's no will involved, the person that's appointed is called an administrator. Now, whether it's an executor or an administrator, the duties are identical. They have to gather together the assets, they have to notify creditors, they have to keep pristine records of everything that they do, because you will have to account at the end of the probate for exactly what existed at the time the decedent passed, everything that comes into the estate, everything that goes out of the estate, and all of that will be included in an accounting that has to balance to the penny at the time that the estate closes. In the meantime, you have to understand that if you're appointed as the personal representative, you have assumed what are called fiduciary responsibilities. You are handling other people's money. Even when you are the only heir of an estate, you don't own any of that money until a judge is satisfied that all just debts have been paid, all taxes have been paid. Only then, when the judge says that you own the money, do you own it. So you are responsible for minding your P's and Q's, they used to say, and keeping incredibly accurate records of everything that you do.
Prepare to be an executor of an estate.
There's not much that you can do in advance. If you are identified in a will as the executor, you either decide I'm up to that responsibility or I'm not. The biggest thing that I would say, and the hardest issue that I've had to deal with, is that some people just don't have a good business sense. And that doesn't mean that they can't act as executors. I've gone through a recent probate where I had a client appointed as executor because she was named in the will, but she had never even written a check. She'd always existed just using automatic transfers. I actually had to teach her how to fill out a check. Now, that's not ideal. You preferably have some background, at least handling your own household finances. And if you're a good, careful steward of your own finances, that is typically the key element to being a good representative of the estate. The other issues that you need to know if you have a good attorney driving you through the process and advising you, you'll be in good shape.
How can proper estate planning help avoid probate?
The single most common and effective way to avoid the need for probate is to see an attorney about having a revocable living trust prepared. Using the trust process, ownership of the assets is transferred out of the individual's personal name, and ownership is transferred over to this trust that they've created. In a sense, because the owner of the property doesn't change, the owner is the trust. Even if the creator of the trust passes away, the owner has not changed. And therefore, whoever has been appointed by the trust document as the successor trustee, they can take over and manage that trust after the creator of the trust has passed away. All of that can be done outside of court. As long as the successor trustee manages things properly and communicates well with the other beneficiaries under the trust, they can stay out of court and get the assets where they belong in a much shorter time and at quite a bit less in attorney fees.
What are some effective strategies for estate planning that you recommend?
Every individual situation is different. In most cases, somebody that owns a home is going to be best served by creating a living trust. Now, when a living trust is prepared, it's not the only document that goes into the overall umbrella that we'd call an estate plan. There are powers of attorney drafted, there are wills drafted, there are healthcare directives drafted, there are deeds transferring any real property into the trust. Typically, for a single person, there's going to be at least 10 different documents in an estate plan. For a married couple, it's going to be a dozen to 15 would be fairly typical. But by having a good estate plan in place, it not only helps avoid probate upon death, it also has people in places of authority, the people that you want in control, will be making financial decisions for you if you become incapacitated. They'll be making medical decisions for you if you become incapacitated. If you haven't done that, it can turn into sometimes just a royal battle among family members over who it is that's going to be running your affairs. And that not only creates a lot of friction, it can drain your estate overnight with legal fees in what are known as conservatorship proceedings. So by getting an estate plan, you're not only doing a favor to your children or your heirs by saving them money on the backside once you've passed, you're doing yourself a favor by avoiding the depletion of your estate if you get, or your children or heirs get involved in a battle during your lifetime over conservatorship.
When should someone consider hiring a probate attorney?
If you have someone close to you that's passed away, you owe it to yourself to talk with an attorney and find out what your alternatives are. As I said earlier, many times a formal probate will not be necessary. There have been many steps taken over the last few decades, and some laws passed that came into effect as recently just April of this year, 2025, that greatly increase the number or the ways in which you can avoid a formal probate. And I won't go into all of the figures and facts on that, but if you consult with a knowledgeable attorney, many times you're able to avoid a formal probate. You may still have to go through some abbreviated court proceedings to get things where they need to go, but the legislature has tried to make it as simple and inexpensive as possible to get assets to the ultimate heirs without the need for a formal probate. And an attorney can help you find your way through that process.
What should clients look for when choosing a probate attorney?
The biggest thing I would say is to know that you have somebody that is diligent and detail-oriented. That's probably more important than even experience, although it's very, very helpful to have an attorney that has experience with a lot of different situations. I don't want to talk against using younger attorneys because I used to be one. And I have a lot of people that hired me and I did good work for them because I was diligent and because I was conscientious. And I would say that that is more important than experience, because I've seen experienced attorneys that have been in practice for a long time that have royally messed things up. Both going for you, if you have a conscientious attorney that has also got years or decades of experience, that's the best choice to make.
How does probate differ for small estates versus larger estates?
I talked earlier about some very recent laws that were passed. Currently, if you have a residence with a value under $750,000, it can be passed without the need for formal probate. If you have personal property under $200,000 roughly, it can be passed without the need for probate. There are also some other abbreviated processes that can be done either with simple court proceedings or with no proceedings at all. But it gets, there's an actual chart that's published by the Judicial Council that goes into all of those. Well, there are scales and the numbers change from year to year, so I don't want to get hung up on that. But the first step, as I said before, is talk with an attorney that understands what those limits are, find out whether some or all of the assets can pass without complicated formal probate, and if all else fails and a formal probate is necessary, then you just go ahead and you do it.
What happens if a will is contested during the probate process?
Most will contests surface very early before the probate is granted. If somebody goes into court, files a petition for probate, a copy of the will has to be attached. That notice is going to go out to everyone that has a stake in the estate. And if someone believes that there are defects in the will that warrant it, they're usually going to show up at the first hearing saying, I object, and the court will give them an opportunity to file a will contest. In some cases, the will contest doesn't surface until after somebody has already been appointed as the personal representative, but usually it happens fairly early on. Until those will contests are litigated or settled, everything is basically in limbo. You can't move forward until the court knows or has decided whether the will that's being submitted to the court is valid.
What advice would you give to someone who's just starting to navigate the probate process?
again, talk with a knowledgeable attorney, somebody that understands the probate process. I don't discourage people from doing some self-help, looking online, doing some research of their own. It's great. You get introduced to a lot of terminology, but unless you have somebody that has an understanding of the overview, a lot of times this is just so confusing to deal with, you can't get from point A to point B without some professional help or guidance.
Are there any resources or tools you recommend for individuals dealing with probate?
There's a huge amount of information available on the internet. I don't discourage clients from looking at that. I've talked with some clients that have found some very helpful guides on sort of how to be an executor. And look into it. If you're watching this video, you're probably already doing that. And you're probably getting a little bit inundated with information and trying to make sense of it. Best resource you're going to have is somebody that's knowledgeable in the probate process, an attorney that's been through the mill on this. They'll be able to make sense of all these loose threads that you've found in your own research.